A quiet federal change just put some of the toughest state gun bans under a bright spotlight. And if you think a $0 NFA tax means you are suddenly safe, that mistake could wreck your life. Quick question before we keep going. Are you subscribed yet? Because this is exactly the kind of legal update that confuses good people. And confusion in gun law can turn into felony charges fast. Hit subscribe right now so you do not miss what comes next. Here's what just happened. Congress cut the federal NFA tax for several items down to zero, and that change took effect on January 1st, 2026. That includes suppressors, short-barreled rifles, short-barreled shotguns, and what the law calls any other weapons. But here is the first big thing most people get wrong. The tax got cut to zero. The NFA did not disappear. The registration system still exists right now. The approval process still exists right now. Background checks still exist right now. So if you heard somebody say, "Bro, SBRs are free now," just build one. Slow down. That is not what happened. Think of it like this. The price tag changed. The gate did not. You may not be paying the old $200 stamp anymore, but federal paperwork and approval are still part of the process today. And state law still matters just as much as before, maybe more. Now this is where it gets interesting. The reason the tax cut matters so much is not just money. It is legal theory. For decades, the NFA was defended as a tax law. That was the core idea. The government taxes these items, tracks them, and requires paperwork tied to that tax. But once the tax drops to zero, people immediately start asking a very simple question. If there is no real tax left, what is the legal foundation for keeping the rest of that system in place? That question is now driving fresh lawsuits against the federal government. Gun rights groups, including the NRA and others, have already signaled or filed challenges arguing that if the tax is gone, the registration scheme becomes much harder to defend the same way it used to be. And that matters for SBR bans at the state level too, because states have long benefited from the fact that short-barreled rifles were already treated as suspicious under old federal law. Once that federal tax idea starts looking weaker, state bans do not look as comfortable anymore. But wait, there is something even more important. This does not mean every SBR ban falls tomorrow. Not even close. It means the legal ground under those bans is getting shakier, and the state that may end up testing that in a big way is New Jersey. If you're finding this helpful, imagine what you'll learn in my next video, where I break down the exact gun laws people think changed in 2026, but actually did not. Subscribe now so you do not miss that one. So let's talk about New Jersey, because this is the part that shocked me. New Jersey does not simply regulate short-barreled rifles. It effectively bans them. Under New Jersey law, a rifle with a barrel under 16 inches, or a firearm made from a rifle or shotgun with an overall length under 26 inches, can fall into the state's prohibited category. And yes, that means the state can treat what many gun owners would call an SBR as contraband. According to the lawsuit challenging the ban, possession can expose someone to a third-degree crime, with prison time in the 3 to 5 year range. Let me break that down in plain English. Imagine you live in another state. You went through the federal process. You filed the paperwork. You got the approval. You did everything by the book. Then you move to New Jersey, or even think about bringing that rifle there. You might assume your federal approval protects you. But here's the crazy part. Federal approval does not erase a state ban. In a state like New Jersey, that rifle can still put you in criminal danger. And that is exactly why a lawsuit was filed on July 18th, 2025 by Firearms Policy Coalition in federal court in New Jersey. The case challenges the state's total ban on short-barreled rifles. By early 2026, the plaintiffs had already asked the court for summary judgment, which means they want the judge to rule based on the law without needing a full trial first. What are they arguing? First, they say an SBR is still just a rifle. It is a bearable arm. It is not some strange sci-fi weapon. It is basically a more compact rifle, often chosen for lawful reasons like home defense, easier handling in tight spaces, storage, and control. The complaint even uses real-world examples like moving through hallways and doorways inside a home. That matters because modern Second Amendment cases ask whether the item is an arm protected by the Constitution. The plaintiffs say the answer is obviously yes. Second, they argue New Jersey's law is not some light rule around paperwork or carry locations. It is a flat ban. And flat bans are much harder for states to defend after the Supreme Court's Bruen decision. Under Bruen, if the conduct is covered by the Second Amendment, the government has to point to a historical tradition of similar firearm regulation. Not just a policy argument. Not just, we think this is safer, it has to show history. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's the part nobody's talking about enough. New Jersey's problem is not just that it bans SBRs. It is that the state has to justify banning rifles based mainly on barrel length or overall length. And the plaintiffs say there is no solid founding era or Reconstruction era tradition of states banning ordinary rifles because they were shorter. Hey, 73% of people watching content like this are not subscribed. Do not be part of that group. Join the people who stay ahead of these legal updates before they become legal disasters. Hit subscribe and stay in the loop. Now let's get to the legal pressure point that could make this case such a big deal. The plaintiffs in the New Jersey case are leaning hard on two ideas. The first is common use. The second is history. Common use sounds fancy, but the idea is simple. If a type of arm is commonly owned by law-abiding people for lawful purposes, it becomes harder for the government to call it dangerous and unusual. And that phrase matters because weapons that are both dangerous and unusual are more vulnerable to bans. The New Jersey plaintiffs point to federal registration numbers showing that by May of 2024, there were about 870,000 registered SBRs in the national system. Their message is straightforward. You cannot call something unusual when hundreds of thousands of Americans already own it legally. Most people think the government only needs to say, short barrels are scary, and that is enough. But the truth after Bruen is very different. Fear is not the test. History is the test. So the plaintiffs also argue that there were no well-established early American laws banning rifles just because they had shorter barrels or shorter overall length. They say the first major federal restriction came in 1934 with the NFA, and that is way too late to prove a deep national tradition. Now, does that mean the plaintiffs automatically win? No. And this is where I need to slow people down. A lawsuit is not a court order. A complaint is not a victory. A motion is not a ruling. As of now, this New Jersey case is important because of the arguments it raises, not because the ban is already gone. But here's the crazy part. The tax cut makes the timing almost perfect for challengers. Why? Because once Congress reduced the tax to zero, the old "this is a tax system" defense started looking thinner. So now you have two lines of attack hitting at once. One line attacks the federal NFA framework after the tax cut. The other line attacks state SBR bans under Bruen's history test. If those two lines start reinforcing each other in court, states with outright bans could face a much tougher road. Let me give you a hypothetical example to explain this. Say a court eventually says the federal government cannot lean on a $0 tax to justify the same old registry scheme the same way it used to. At the same time, another court says a state cannot ban short rifles because they are common arms and there is no historical tradition for the ban. If both of those ideas grow in the courts, the whole legal story around SBRs changes, not overnight, but dramatically. And that is why this New Jersey lawsuit could matter far beyond New Jersey. Lawyers in other states watch these cases closely. If one state ban falls on strong Second Amendment grounds, the same blueprint gets copied. The facts change a little. The state names change. but the legal engine stays the same. Here is what most people still get wrong. They hear state bans in trouble and think that means go buy now. No, that is how people get charged. Right now, the safest mindset is this: nothing has changed unless a court order, statute, or official rule actually changed where you live. Until then, your state law is still your state law. This information is moving fast, and the next court ruling or filing could shift the entire conversation again. Subscribe right now, because my next breakdown will cover what gun owners still have to file in 2026 even after the tax dropped to zero, and what mistakes could still turn into charges. So what should you actually do with this information? First, do not confuse federal tax relief with state legality. Those are not the same thing. A $0 federal stamp does not cancel a state prohibition. Second, do not rely on social media victory laps. A lot of people online talk like a headline is a final judgment. It is not. Third, if you live in a strict state, stop assuming federal paperwork makes you untouchable. It does not. And fourth, watch this New Jersey case carefully, because it may tell us how courts are going to think about SBR bans in the post-tax cut world. The key question is simple. Are these rifles protected arms that states cannot ban outright, or can states still wall them off based on old public safety arguments and old legal habits? That fight is now very real. This is also why the end of the pistol brace rule matters in the background. After the federal government dropped its appeal in the mock case, challengers got another reason to argue that the line between braced pistols, compact rifles, and what counts as an SBR has been legally unstable for a while. That does not automatically kill state bans either, but it adds pressure, and pressure matters. So here is the bottom line. The New Jersey lawsuit has not changed the law yet, but it is attacking one of the weakest looking parts of modern gun regulation at exactly the moment federal tax law stopped giving that area the same cover it used to have. That is why this case matters. That is why other states are paying attention, and that is why you should too. If this video helped you make sense of a very messy legal story, do me one favor and subscribe right now. I spend hours cutting through the noise so you can protect your rights, protect your family, and avoid mistakes that are hard to undo. At the end of the day, the biggest takeaway is simple. The NFA tax cut did not make SBR laws disappear, but it did open a new legal front that could put state bans under serious pressure. New Jersey may be the test case that shows whether courts are ready to treat short-barreled rifles like protected arms instead of automatic contraband. Subscribe, stay informed, and never make gun law decisions based on rumors. And one last time, this video is for education only, not legal advice. If your freedom is on the line, talk to a qualified attorney in your state.